The next case set for argument this morning is State of Ohio versus Arsie Thompson. It's case number 18CA011292. Both parties are represented by counsel, so each will have 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. Let me know if you're going to reserve rebuttal time, and I'll keep track of that for you. As you both know, the oral arguments are recorded. We ask that you stay at the podium and keep your voice up so we get a good recording for the court's YouTube channel. I don't recall if children are involved in this case, but if so, please just use initials. Thank you for that last argument, Judge Carr. And we've read the briefs and are ready to proceed if you are.
Attorney Matthew Bobrowski here, once again, on behalf of Attorney Huff, who was retained counsel of this appeal, and he was also retained counsel at the trial level. Obviously, the issue before you today, the assignment of error, is regarding to whether the trial court's denial of Mr. Thompson's motion to suppress was supported by competent and credible evidence. As a preliminary matter, and towards the end of the brief, Mr. Duff did address the issue. The trial court, when it denied Mr. Thompson's motion to suppress, did so by saying this matter came before the court for hearing on October 25th, 2017 upon the defendant's motion to suppress, based upon the evidence presented, testimony given, credibility of the witnesses, and for good cause shown, the court hereby denies the defendant's motion to suppress. We referred you to your earlier decision in State versus Purefoy, in which a trial court denied, in even more summary language, a motion to suppress, saying, upon due consideration of this court, the defendant's motion to suppress is hereby denied. What is the commonality between this case and Purefoy is that neither court issued findings of fact. So while the trial court in this case did say another sentence, essentially, basically listing things in a very general and vanilla way, it was so generic as to have really no substance in terms of findings of fact.
Counsel, at the actual hearing, when all the evidence was presented at the trial court, orally indicate what his findings were or anything, or talk about that?
No, not to my recollection. There was no real any kind of enunciation of any findings of fact, any kind of particular things that the trial court was basing its ruling on. Rather, what did happen was the parties were allowed to file closing briefs. What happened essentially was the evidence was adduced, and the court gave the parties the ability to file briefs. So really, there was nothing finalized at the hearings. Everything came simply through the court spoke through its journal entry. Now, I understand that what the trial court in this case said and what the trial court in Purefoy said are different. I mean, there is more to what this trial court said, and essentially you could stretch it to say they looked at they listened to the witnesses, they looked at the evidence adduced, including the inventory sheet, the search warrant, and so on, and that's what they based their decision on. However, they're not actual findings of fact. There's nothing there. It's arguing with kind of smoke in the sense that, yes, we have the transcript, but obviously in Purefoy there was a transcript. There was evidence adduced and put into the record in both cases. But in both cases, there were no findings of fact. In Purefoy, it was remanded for findings of fact to be issued. That's what we would hope to happen here. Be that as it may, I still think that it's necessary to argue why we think the motion to suppress was in fact wrongly denied. Obviously, at issue was the search of Mr. Thompson's residence, and it was tied to several drug buys that happened in October and November of 2015. An arrest warrant was obtained after I believe the second drug buy from Lorain Municipal Court, but two further drug buys were done. Officer Bonkowski obtained a search warrant on November 12th. Now, Mr. Thompson's position has always been, and it was his position at the suppression hearing, that the search of his residence occurred on November 12th, not on November 13th, as the inventory sheet in Officer Bonkowski's testimony stated. It's his position that, in fact, the date that it occurred coincides with the date on which he was indicted. Now, admittedly, the indictment does say on or about November 12th. There is that obvious equivocation, that obvious wiggle room that you have there. However, we believe that the evidence shows that the search occurred in the morning of November 12th, not in the morning of November 13th, which would mean that the search warrant was not obtained until after the search was already conducted. Officer Bonkowski obviously testified that that's incorrect. The grand jury simply got it wrong, that he obtained the search warrant on November 12th, and that the search was conducted legally and procedurally correctly on November 13th. However, it's our position that, based upon the discrepancy, particularly with regard to the indictment, that the only way the state could have known that Mr. Thompson had possession of cocaine on November 12th was if they had already been into his home, been into the residence. Obviously, they would have the evidence from the drug buys, but the only way they would have known that he had possession of the amount of cocaine which he was alleged to have had would have been as if they had been into his home on November 12th, which was what was stated on the indictment.
Weren't the prior buys by the confidential informant at the house?
3 of the 4 were. I believe the 4th buy, if I'm not mistaken, occurred at a Dairy Mart or some sort of convenience store outside of the home. So, yes, there were drug buys done at the residence. However, there's no evidence that he would have had possession of over 100 grams of cocaine. There was no way they could have knowledge of that at the residence prior to conducting a search. Now, if the search was conducted on November 13th, the indictment is simply wrong, then obviously everything was procedurally done correctly. However, it's our position that the indictment is not wrong and that the evidence adduced should have led to the suppression of the evidence. However, this brings me back to my earlier point in that there are no findings of fact issue. I'm re-arguing up here somewhat, extemporaneously the arguments that were made at suppression hearing that the court already ruled on. But what is not clear is what they actually ruled upon. What they found that, in fact, the evidence that the warrant was issued as is said on the November 12th, which is there's no doubt that the warrant was issued on the 12th, but whether the indictment was correct or the indictment was wrong, or when the search itself was conducted. Obviously, if the search was conducted before the warrant was issued, it would be invalid. It would be illegal. It would be an illegal search of Mr. Thompson's residence. So where we are is without the findings of fact, that is essentially what we have. We have we have the testimony at trial, we have the court's ruling, and yes, if saying that they looked at the credibility, they looked at the evidence, they listened to the witnesses is enough to encompass, to be findings of fact, then that's the end of it. However, we don't believe that that's what the law requires, what this court has required previously. For that reason, we would ask that this matter be remanded for findings of fact. If not, if this court does not overturn it on the merits today in its ruling as regards the motion to suppress, I'm not going to reserve any time for rebuttal. Thank you.
All right, thank you for your argument. I don't see any questions, so thank you. State has 15 minutes as well.
Good morning, Your Honors. May it please the Court, Lindsay Paprocki on behalf of the State of Ohio. I'm going to begin with why the motion to suppress was properly denied, and then get into why appellate review remains proper despite the brevity of the trial court's journal entry denying the motion to suppress. Thompson is essentially contending that he was subject to a warrantless search because he alleges that the search of his residence occurred prior to the issuance of a valid search warrant. Thompson's assertion that the Lorain Police Department conducted a search of his residence during the morning hours of November 12, 2015, prior to the issuance of a search warrant later that afternoon, is simply belied by the record. Detective Bonkowski, who was the sole witness to testify at the suppression hearing, consistently testified that he obtained the search warrant in the afternoon of November 12, 2015, and as was customary, searched Thompson's residence the following afternoon on November 13, 2015. Thompson, however, took this testimony to look at count 1 of his original indictment, where he was charged with possession of drugs on or about November 12, 2015, to argue that if the offense occurred as charged, that the only possible way the Lorain Police Department could have known that he was in possession of drugs on November 12th was if they had been in his residence in the morning, found the cocaine, and then obtained a search warrant in the afternoon. As Thompson has conceded, even though in his brief he argued that the indictment charged him on November 12th, 2015, the indictment actually read that he was charged on or about November 12th, 2015. And as this court is well aware, precise dates and times are not ordinarily elements of the offense, and a certain degree of inexactitude is allowed where it comes to the indictment and is not fatal to the prosecution. Here, the indictment was simply meant to advise Thompson of the approximate date on which the offense occurred. Moreover, Thompson is attacking Detective Bonkowski's credibility by claiming that he had knowledge of the drugs found in his residence before he obtained a search warrant. However, the documents provided by the state at the suppression hearing, including the search warrant, which was dated November 12th, and the inventory log, which was dated November 13th, coincide with and support Detective Bonkowski's testimony. It is important to note that Thompson signed the inventory log dated November 13th, 2015, and indicated that he received a copy of the inventory log and the search warrant at the time the search was executed, which discounts his theory of the events. Detective Bonkowski indicated at the suppression hearing that the date in the indictment was an error. To correct that error, following the suppression hearing, the state moved to amend the indictment to conform with the evidence presented at the hearing to list that several counts in the indictment occurred on or about November 13, 2015. That motion went unopposed. On the same date that the trial court denied Thompson's motion to suppress, it granted the state's motion, which was unopposed, to amend the indictment. It is the state's position that based upon the narrow factual issue presented at the suppression hearing, the credibility of Detective Bonkowski's testimony, and the straightforward and supporting documentary evidence presented by the state, that the trial court had competent, credible evidence before it to deny Thompson's motion to suppress. Moreover, once the indictment was amended by the trial court to conform with the evidence presented at the trial, at the hearing, Thompson's argument became all but moot. The indictment as it stands, and as it stood at the time of the trial court's decision, read that Thompson was charged on or about November 13, 2015, which conforms with the evidence presented at the suppression hearing and supports that the search occurred that day. Moving to the argument about the factual findings sufficient for appellate review. In our merit brief, we acknowledge this court's finding in Purefoy. And we acknowledge also that the court issued a short journal entry. It did indicate, however, that it considered the evidence presented at the suppression hearing, the testimony given, and the credibility of the witnesses, which there was only one. It is the state's position that based on the testimony of the sole witness, the nature of the narrow factual issue addressed, and the straightforward documentary evidence, and the amendment to the indictment, that the record is sufficient to allow a full review of the limited suppression issue. Several other appellate courts have taken the position that where a trial court's findings of fact were deficient in isolation, that it may provide a sufficient basis for appellate review when taken together with the entire record.
Counsel, can I ask, is it true that the motion for suppression held within it 4 legal arguments?
Correct. It did. It was an amended motion to suppress, and it held within it, I believe, 4 or 5 legal arguments. And at the beginning of the suppression hearing, both parties stipulated that it would be limited to the one issue. Based on those arguments, we ask that the trial court's decision be affirmed because it properly denied Thompson's motion to suppress.
Of course, you can't tell that by reading this entry, that it was limited to one issue. But you're saying that's in the record, the stipulation.
The stipulation is in the record
Is in the
at
record.
the hearing.
Now, let me see if the judges have any questions. The counsel. All right, thank you both for your arguments this morning. The court will take the matter under advisement, issue a decision in due course. Clerk of courts will certainly mail you both a copy of the decision on the day it's released. And the decisions are also posted on the Supreme Court of Ohio's website. Again, thank you for your arguments this morning.